Good morning, dear students. Today we are going to start a new chapter, Understanding Our Criminal Justice System. So let's start. When we see someone violating the law, we immediately think of informing the police. You might have seen, either in real life or in the movies, police officers filing reports and arresting persons. Because of the role played by the police in arresting persons, we often get confused and think that it is the police who decide whether a person is guilty or not. This, however, is far from true. After a person is arrested, it is the court of law that decides whether the accused person is guilty or not. According to the Constitution, every individual charged of a crime has to be given a fair trial. Do you know what it means to get a fair trial? Have you ever heard of an FIR? Or do you know who is a public prosecutor? In this chapter, we use a fictional case of theft to try cases go through a process that is similar to the one discussed in our fictional case. Therefore, understanding these processes as well as the role that different persons should play within the criminal justice system is crucial so that if ever the occasion should arise, you are aware of the process that should be followed. See, conflicts between people or groups often arise in communities. If these conflicts cannot be resolved, we depend on the criminal justice system. Courts resolve cases of conflicts that occur in communities, maintain social order, mitigate crime, and impose penalties on those who violate laws. According to the Constitution of India, every person who has violated a law has to be given a fair trial. Therefore, those accused of crimes are given protection against abuse through investigation and prosecution processes. You must have seen that there might be some public anger against a person who is accused of some heinous crime. So it is the duty of the police to protect the life of that person also, even though he is charged of a crime like rape. But the security of his life is to be ensured by the police. Okay, and even that person who is accused of rape or any other heinous crime must be given a fair trial. He should know the crime committed and are reformative in nature, giving an offender a second chance. So the kind of punishment that is given, it should be in the proportion of the crime committed, and it should be reformative. Reformative means the person should change his conduct, right, and should become a normal citizen. For that, whatever could be possible could be done, should be done. It should be reformative so that the person doesn't commit the same crime again and become a normal citizen, right? So it is the court's responsibility to see that justice is ensured to offenders as well as victims. So criminal justice system in the country broadly has certain objectives, right? First objective is to prevent the occurrence of a crime, to punish the transgressors and the criminals. Third is to rehabilitate the transgressors and the criminals, to compensate the victims as far as possible, to maintain law and order in the society, to deter the offenders from committing any criminal act in the future. Right? All this we have discussed in this. So let us just go through this storyboard. At their apartment, stories. I plead not guilty and I claim trial. Shinde is getting dressed. She has been frantically searching for her gold chain for over an hour. I'm sure it was this drawer. Where could it be? Mr. Shinde says, hurry up. We are going to be late for the wedding. I can't find my gold chain. It is not in the drawer. I suspect that Shanti might have stolen it. She always spends a long time dusting my room. Shanti Hembram has been working in the house for the past 3 years. Shanti, have you begun to steal now? And that too, my gold chain? Bring your trunk. I want to search it. We have called the police, so if you have the chain, return it now. Madam, I haven't stolen it. Mr. Shinde searches Shanti's trunk and finds an envelope with rupees 10,000 in it. He screams at Shanti, saying that this is the money she's got from selling the chain. Sir, my brother and I have been saving this money over the last 1 year. We want to buy a bull when we go to our village. Madam, I am innocent. Mr. Shinde comes to the police station. I have come to file an FIR. There has been a theft in my house. My maid Shanti has stolen my wife's necklace. Yes. Sub Inspector S.I. Rao records Mr. Shinde's FIR. Mr. Shinde returns with Sub Inspector Rao. I will now write the statement that Mr. and Mrs. Shinde make about this theft. Let me seal the envelope that has the money and take it with me as evidence. I am arresting Shanti and taking her to the police. This is my hard earned money. And on 19 July, Sushil, Shanti's brother, arrives and pleads with S.I. Rao to release Shanti. She has been arrested for the theft of a gold chain. You can go to a court. You can go to court and get a bail order. But where will I get the money to hire a lawyer? And who will stand as surety for her? You have taken all of our savings and sealed it. S.I. Rao forcibly keeps Sushil in the police station for 2 days. Sushil is abused and beaten by S.I. Rao and other police constables. They try and make him confess that he and his sister Shanti had a gang of domestic servants that have stolen jewelry from other homes. There have there have been other complaints of theft of jewelry from Shinte's neighborhood. As Sushil keeps repeating that he is an innocent factory worker, the police let him go after 2 days. On 23rd August 2006, although the court granted bail to Shanti after a month, she was unable to get anyone to stand surety for her for rupees 20,000. She therefore continued to be in jail. She is very traumatized. She is worried about what will happen during the trial. What will happen to me? I haven't done anything wrong. And yet I am behind bars just because Madam suspects me. And the money that we have been saving, will I ever get justice? Will I ever get it back? Copy of the charge sheet, including statements of witness to Shanti. Shanti tells the court that she has no lawyer to defend her against this false case of theft. The magistrate appoints Advocate Kamla Roy as Shanti's defense lawyer at the government's expense. According to Article 22 of the Constitution, every person has a fundamental right to be defended by a lawyer. Article 39A of the Constitution places a duty upon the state to provide a lawyer to any citizen who is unable to engage one due to poverty or other disability. Advocate Kamla Roy meets Shanti in the court. Here are my case papers. I have been falsely accused of stealing my employer's gold chain. They found rupees 10,000 in Shanti's trunk and said that this was the money she got from stealing the chain. But that is but that is the money that we have been saving together. On 11th December, the court frames a charge sheet of theft, a charge of theft of Mrs. Shinde's gold chain and possession of money rupees 10,000 got from selling stolen property against Shanti. I plead not guilty and I claim trial. 8th March, the public prosecutor appears in the case on behalf of the state. He presents Mrs. and Mr. Shinde as a key witness. So tell me, Mrs. Shinde, how did the gold chain go missing? I had kept my chain in the drawer. Shanti stole it. No other outsider except Shanti goes into my room. Mr. Shinde searched her trunk in front of me, and we were shocked to find rupees 10,000 in an envelope. Witness Mrs. Shinde. So, what you are basically saying is that you didn't see Shanti steal the chain, nor did you recover the chain on Shanti. Also, in 3 years that she has worked for you, nothing has been stolen from the house. You were also regularly paying her rupees 1,000 as salary each month. On 20th April, Advocate Roy examines Sushil and his employer as defense witness. Through their testimonies, she is able to show that rupees 10,000 found in Shanti's trunk could well be the earnings of Sushil and Shanti. As the trial is nearing completion, Sushil learns that Inspector Sharma has busted a gang of young men who have been stealing jewelry from Mr. Shinde's neighborhood. Some of Mr. Shinde's son's friends are part of this gang. Mrs. Shinde's chain has been found on them. Sushil tells Advocate Roy about this. Advocate Roy now calls Inspector Sharma as a defense witness. Inspector Sharma, can you show and tell us what you have found? Here is the chain that has been identified by Mrs. Shinde as hers. We busted a gang of boys who had stolen the chain. These boys have admitted that they stole the chain. On 15th July, the judge hears the testimony of all witnesses. After the testimony of Inspector Sharma, Advocate Roy argues before the judge that it has now been established that Shanti is innocent and should be acquitted. Shanti, you are hereby acquitted of the charge of theft. The police will hand over to you the rupees 10,000 that they had sealed. In my that made you spend time in jail. From the above incident, you can see that the four key players in the criminal justice system are the police, the public prosecutor, the defense lawyer, and the judge. You have seen the roles each of them played in the above case. Now let us try and understand their roles more generally. What is the role of the police in investigating a crime? One important function of the police is to investigate any complaint about the commission of a crime. And investigation includes recording statements of witnesses and collecting different kinds of evidence. On the basis of the investigation, the police are required to form an opinion. If the police think that the evidence points to the guilt of the accused person, then they file a charge sheet in the court. As stated in the beginning of this chapter, it is not the job of the police to decide whether a person is guilty or innocent. That is for the judge to decide. So basically, the police force was instituted to maintain law and order within a state. Any crime or unlawful act which happens is a threat to the law and order situation. Therefore, it is an important responsibility of the police to investigate every crime. They need to establish if a crime has actually taken place. If a matter is brought to the notice of the police by the people, then the statement of the witnesses should be recorded by the police. If the police is certain of the evidences against the accused, Then they file a charge sheet in the court. This points to the offenses a person is guilty or innocent. Okay? And if the police detains or arrest someone on the basis of evidence, then the arrested person also has a rights under Article 22 of the Constitution. Article 22 states that no person who is arrested shall be detained in custody without being informed of the grounds of such arrest. So the person who is going to be arrested must know on what ground he is being arrested. So he should be or she should be informed about the reason of his arrest. And the arrested person shall have the right to consult and to be defended by a legal practitioner of his choice. It also states that every person who is arrested and detained in a custody shall be produced before the nearest magistrate within a period of 24 hours. The arrested person cannot be detained in custody beyond the said period without the authority of a magistrate. Okay. An arrested person should be allowed to inform a friend or a relative about the arrest and where he or she is being held. The arresting officer must inform the arrested person when she or he is brought to the police station of this right and is required to make an entry in the diary as to who was informed. So, the right not to be ill treated or tortured during the arrest or in the custody. So, whatever confessions made in police custody cannot be used as evidence against the accused. A boy, right? So, here we go through the the DK Basu guidelines. The police officials who carry out the arrest or interrogation should wear clear, accurate, and visible identification and name tags with the designations. So they must show their ID, identification, right, designations at the time of arrest to the person who is being arrested. A memo of arrest should be prepared at the time of arrest and should include the time, date of arrest. It should also be attested by at least one witness who could include a family member of the person arrested. The arrested memo should be countersigned by the person arrested. The person arrested, detained, or being interrogated has a right to inform a relative, friend. This we have already we have already spoken of. A relative, friend, or a well-wisher. When a friend or relative lives outside the district, the time, place of arrest, and venue of custody must be notified by the police within 8 to 12 hours after arrest. Right? Now, the investigation starts with the lodging of an FIR. Right? Generally, it starts with an FIR. So, an FIR is lodged when it is when a person gives information about a cognizable offense. So, what is a cognizable offense? Cognizable offenses are those under which a police officer can make an arrest without an arrest warrant. Some examples are murder, dowry, death, kidnapping, and theft. Right? And non-cognizable offenses are those which a police officer cannot arrest without a warrant. Some examples are assault, cheating, forgery, and defamation. Right? So, under cognizable offense, we see further details, further points of differences are there. The police officer has to receive the first information report relating to the cognizable offense, which can be without the magistrate permission, and in it enter it in the general diary and immediately start the investigation. Whereas a in a non-cognizable offense, the police officer cannot receive or record the FIR unless he obtains prior permission from the magistrate. the investigation also cannot be started without the prior permission of the magistrate. So the permission from the magistrate is required for a non-cognizable offense, right? And for a cognizable offense, um, it can be started. The investigation can start, right? FIR relating to the cognizable offense, which can be without magistrate permission. So in case of cognizable offense, we don't need the magistrate's permission, and in case of non-cognizable offense, magistrate's permission is required. An FIR or first information report is generally recorded by the local police officer on receipt of any complaint related to a cognizable offense. It is a document that officially registers that your complaint has been received and understood. Okay, so it is an FIR or a first information report is generally recorded by the local police officer on receipt of any complaint related to a cognizable offense. It is a document that officially registers that your complaint has been received and understood. Okay, I hope you have understood this, and uh, let me discuss one more point regarding the non-cognizable offense. A non-cognizable officer may receive a complaint and register it, but cannot investigate without a magistrate's order or make arrests without a warrant. He cannot even file an FIR without judicial permission. So, for a non-cognizable offense or a complaint or first FIR cannot be done without magistrate's order, or investigation cannot be started without magistrate order, or make arrest, or even arrest cannot happen without a warrant for a non-cognizable offense. But for a cognizable offense, there is no need of an arrest warrant also. And we have discussed the categories of cognizable offenses. Cognizable offenses are murder, dowry, death, kidnapping, and theft. Whereas non-cognizable offenses are those under which a police officer cannot arrest without a warrant. Some of the examples are assault, cheating, forgery, and defamation. Okay, so till here we discuss, and in the next part we shall discuss the role of the public prosecutor. Thank you.